Page 37, my lord, of the bundle.
Yes.
Paragraph 28, 29 and 30 thereof. The same arrangements we have with Ms. Alexandra applies also to the accusers of files, the bail receipt, bail record, and the cellular phone.
Will that be the discussion outside court?
The discussion outside court, that's correct. Then the rest, you have to submit, to make submissions rather, my lord.
In respect of all of them?
Of all of them. Okay. However, my lord will realize that it appears to be a repetition of the request there too, on the same charge. So if I make submissions, for example, on count 1, it will be applicable to similar questions on the other counts as well. So I need not go to count by count.
All right, fine.
That is the agreement that we agreed on. That I need not do that if
no, fine. That's okay. I think that will be helpful.
As a court, Mrs. Malone.
Thank you.
Before I even start with the response thereto, may I draw the court's attention to the Cooper case, once again, which I have highlighted to the court on the 18th. On my computer printed.
You take me to a paragraph?
The third paragraph, or the third and the fourth paragraph of page 2 of 16 in the Cooper matter, which I've handed.
Okay, just a second. I have a copy. Did you say paragraphs 3 and 4?
No, 4 and 5. My mistake, man. 4 and 5, my lord. The 4 starts with an accused is not entitled to be informed. That is on page 2 of 6.
Okay, no, okay, just a minute. Yes, paragraphs 4 and 5.
And 5, my lord. 4 reads, an accused is not entitled to be informed of every detail of the case against him, and the prosecution should not be tied down with further particulars in a way which would limit its case unfairly at the trial. I will stop there, my lord, and proceed to the third line from the last line in the same paragraph. The use of the particulars is intended to meet a requirement imposed in fairness and justice to both the accused and the prosecution. That's the principle. And then paragraph 5 reads, when trials of fact come to deal with circumstantial evidence and, as opposed to all, inferences to be drawn therefrom, they must be careful to distinguish between inference or speculation. There can be no inference unless there are objective facts from which to infer the other facts which is sought to establish. I will refer to this paragraph in reply to some of the requests by accused 1, 2, 3, and 5. On the same Cooper case, my lord, at 885 to 886,
which would be page of
11 of 16.
Yes.
The last paragraph just above the line where it divides now page 885 and 886.
That's paragraph 4.
That's paragraph 4, my lord. Which goes up to the next page 12 of 16, line 2. In summary, what that paragraph says, my lord, all this paragraph says, whereas the state is obliged to provide particulars of the material facts that it intends to prove, no obligation rests on it to disclose the evidence by means of which the facts are to be proved. When considering an application for particulars, the guiding question is whether the accused has a reasonable need for the additional information to prepare and submit his defense. This was Cooper prior to the Constitution.
Just a second. Where did you read?
My lord, if paragraph 4 and 5 up to the next page is exactly what I'm saying now.
Okay,
just in summary.
Okay,
just in summary.
that's okay.
Thank you, ma'am. Now, in Himstra criminal procedure, on pages 14 to 23, it summarizes as follows as well, and so far as section 87 is concerned.
Pages?
14 to 23, my lord.
Okay.
It's summarized as follows. Insofar as further particulars are concerned, in now the constitutional era. Now, the accused persons are mostly entitled to a reasonable degree of disclosure of the docket. The difference between evidence on the one hand and information which fairly illustrates the case the state intends advancing on the other is no longer of great significance. That does not mean that the difference in principle between the two has disappeared. Further particulars form part of the charge sheet and contribute to a circumscription of what the state has to prove, and the state is, of course, bound by the particulars it discloses. Evidence, on the other hand, is given as a matter of fairness in order to inform the accused about the case to be expected and in order to allow him to prepare a defense. The accused is still entitled to obtain details of means of request of what the facts are to be proved, but not how they are going to be proved. If the state does not know certain facts, it will not be compelled to give the particulars thereto. Accused persons are not entitled to be informed about every legal particular of the case against them. Where, for instance, particulars are unknown to the prosecutor, it is sufficient in terms of section 84, subsection 2, for the state to say so. The state is obliged to give particulars of facts upon which an allegation of common purpose is based. That is now under the Van Hook matter of Weber versus Regional Court Magistrates in 1969, subsection 4. 1969, volume 4, SA 394 in Southwestern SWA, prior to the Constitution. Once again, I keep on referring to the Erasmus case. Page 19, paragraph 41. The access to the police docket is primarily aimed at promoting fairness in that the accused is told in advance what the expected evidence will be. Insofar as the court has to consider this fact and the potential prejudice to the accused, the fact that an accused has been provided with the contents of the docket may impact thereon, insofar as the further particulars are concerned. Further, paragraph 62 says, The danger on page 31, my lord, the danger exists where matters of evidence is admitted at this stage that otherwise inadmissible material is placed before the court under the guise of further particulars in terms of section 87 to the detriment of the parties.
Is that what you said the other day when you submit and indicate that if A number so and so, A48, A77 are admitted and disclosed inadmissible as they may be at the stage, that may be detrimental to the parties?
As the court pleases, my lord. Therefore, the court must look at the interest and possible prejudice to the accused or the state if particulars requested are refused or allowed. And the court must also look at the administration of justice if such particulars are refused or allowed. Now 1.1 says on page 17, apart from the 5 accused mentioned in the indictment, were there any other persons involved in the alleged conspiracy? If so, how many other conspirators were there? In terms of the indictment, on the summary thereof, the state did indicate that there are other people on part A of the indictment.
Part A of the summary.
Of the summary. My apologies, ma'am.
Okay.
Even on count 1, the wording thereof, it is indicated that the accused conspired among themselves and with others presently unknown to the state. Now, this 1.1 seemed to be a request besides what is already known by the accused. We need more of that. That's basically what this request is all about. How the number of the conspirators are going to assist the accused to plead escapes me. Now, 1.1 goes hand in hand with 1.2 insofar as now the identity of those people. I'm trying to understand, my lord, in 1.1 as to if there are 11 conspirators, what difference does it make if there are 3 conspirators for one to plead? Does the accused need, or is there a reasonable need for additional information insofar as to the number of conspirators in order for the accused to plead to the charge? If one looks at the charge that if only 2 minds, mere 2 minds meeting, conspiracy is committed. Now we have 5 accused which the state alleges all 5 of them conspired. How the number thereof is going to change or in any way be unfair to the accused in order to plead to the charges escapes me. The reply thereto is on page 38, where we still indicate, as is indicated on the summary of substantial facts to the indictment, that there are others involved indeed. We went on further to indicate to the accused that the investigation in relation to those people is ongoing, and we also gave a reasonable explanation as to why the identity of those people should not be disclosed at this stage. Which takes me to 1.2. Who are these other co-conspirators? Now, my lord, I read from page 32 of the Erasmus judgment that the court should also consider the interest and the possible prejudice to the accused or the state if particulars are refused or allowed. Let us make an example and say, besides the fact that we have indicated that the son of accused number 4 is also indicated as one of the co-conspirators, we disclose other people who might be even sitting in court, not being aware that there are investigations against them. In weighing the interest and the possible prejudice to the state, if the state is ordered to disclose those names, if I can put a pause therein, the name of accused number 4's son was indicated during the bail application. That is a sought person in relation to this case. At present, my lord, he is not in South Africa. And he has made his intentions clear that he is not coming to South Africa. Now the state has to go through all the process of extradition and all of that in order to have this person brought to South Africa. There are a lot of resources that needs to be employed in such an exercise. He was not even yet arrested. He was merely asked to approach the police because certain information was going to be needed from him, and it disappeared. Now, if the state is ordered to give names of co-conspirators and they vanish, is that not prejudice to the state? If I use the very same example, if accused number 4's son is not part of these accused, is there any prejudice that these present accused are going to suffer in pleading or not pleading to the charges if he's not here or not? Is there any prejudice? My submission would be none, zero, zilch. They have to face the charges and the allegations as against them being present. The presence or not of accused number 4's son will not have any prejudice as to how they prepare their case. I would love them to call him as a defense witness if they want to. Then he will have to come to court. Then we'll deal with that, if it ever happens. I'm just trying to highlight, Your Lordship, the danger or the prejudice that the state might have if it is ordered to divulge the identities of the other co-conspirators. There was, last submission, I see it's almost lunchtime. There was an indication by my colleague, Mr. Van der Merwe, that by the state making an inclination that there are others involved and that their identities are known to the state, it then supposes or it shows that the state's case is not ready or is not trial ready. That is why I, on the previous occasions, made reference to your lordship to section 155 of the Criminal Procedure Act, which provides that any number of people may be charged, or any number of participants in the same offense may be charged or tried together. Not that they shall be charged or tried together. Insofar as the 5 accused before you, my lord, is concerned, the state is ready to try them. .3 says, lastly, to just deal with 1.1 before I go to 1.4. If so, the identities of these persons and the extent of their involvement in the conspiracy are requested. Now, let me make an example, my lord. The accused are facing a mail account where the deceased is shot at by accused 1, 2, and 3. Then accused number 4 puts the body of the deceased in his car and drive to a place.
Just a second. Shot by accused 1, 2, and 3.
I'm making an example, my lord.
No, I'm with you.
And then number 4 is requested, take the body into your car and go and give it to accused number 5, who owns a scrapyard. And then accused number 5 is given the body and then he destroys the body or uses a machinery to cut the body into pieces. But before the court is accused 1, 2, and 3. And then the state is asked, who are the other co-conspirators? Give us the identity. And if so, if the identity is known, give us the extent of their involvement in the conspiracy. Now the state says, I'm not going to give the identity of this person, but the role that he played is that he chopped into pieces the body of the deceased. Immediately, the lights are on. If number 5 is sitting there, you will know, I'm the one who chopped the body. By so doing, we are divulging the identity, but not saying it so. So 1.3 and 1.2 go hand to hand. If the court orders the state to divulge the involvement, or what role did those co-conspirators who are not here played? And same is then given to the court. The entire operation of this investigation will be jeopardized. If the court makes sense of my example.
Yeah, no, I'm with you.
May we take the London Chamber?
Right, thank you. The court adjourns for one.
You lost.